A very good morning, everyone. Apologies for the delay, but welcome to this Drawing the Pacific Blue Line webinar series, a series brought to you by the Pacific Network on Globalization, the Pacific Conference of Churches, Piango, and Dawn, collective mobilizing Pacific voices and expertise on the issue of oceans and in particular the issue of seabed mining. Just some very housekeeping matters. Please, if I could ask all participants to have your mics on mute. And I'll hand it over to Maureen Pendrell, who is the coordinator of PANG, to provide us some introductions and welcome our panelists for this morning. Once again, very good morning, Bulovinaka.
Hi, everybody. It's really wonderful to be back online again on the Drawing the Blue Line series. And it is my really great privilege to be hosting this particular one. And in particular, because of the two people who will be speaking shortly. We haven't been on the mat together in a while with both Julian and Julie. On the mat in a while on this very important topic, which both Blue Ocean Law has been a very steadfast friend in accompanying us in terms of international law, Indigenous people's rights, and human rights in particular. So I'm really, really pleased to be back on the mat with both Julian and Julie to take us through this deep dive in the seminar to really look at the power of framing, challenging the standard accounts of deep sea mining, and the call to really recalibrate in order to comply with international legal requirements that are necessary to protect Indigenous people's rights, and particularly in the context of this part of the world where rights of Indigenous peoples have been denied within our own jurisdictions and more so within international law and ISA. So both Julian and Julie will take us in a deep dive, looking at their report that came out titled The Second Wave of Due Diligence, the case for incorporating FPIC into the deep sea mining regulatory regime. So it is without further ado, I know time is of essence, and we have about an hour and 30 minutes. Both Julian and Julie will speak for about half an hour. We encourage all participants, please, to send your questions as you listen to the interventions. And certainly we will come to Q&A at the end of that 30 minutes. Each will speak for about 15 minutes. And I know Julian will try to get to his 15 minutes, but I think there is much to go through. So without further ado, I could invite Julian to the mat first and then Julie after.
Bulivinaka, Maureen, and everyone else in Fiji, our partners at Pacific Network on Globalization, Hafaday from Guam, where I'm based, and good morning to you all. Yeah, so we may not take that whole time, I imagine, and in the hope that we can have more of a conversation toward the end and maybe open it up to more Q&A. This is pretty informal. So Maureen and our partners had asked us to basically share with you folks sort of the results of several years of sort of research and thinking and conceptualizing around the dominant narrative surrounding deep sea mining as this new extractive industry. As we know, the Pacific matters. I mean, my God, most of the deep sea mining is totally slated to occur in and around the EEZs of several Pacific Island states. I think to be more specific, I mean, by the time we wrote our article, the one that Maureen mentioned, entitled Second Wave Due Diligence, that was a law article we published, I think, early 2019 in Stanford Environmental Law Journal. And so that was the last time we looked at this issue as a team. We've done some other projects since then. So in some ways, we're refreshing ourselves too with some of the arguments that we have made. But back in the day in 2019, when we came out with that, I think the ISA at that time had issued, and when I say ISA, of course, I mean the International Seabed Authority based in Kingston. I don't know if everyone on the call is aware, but basically this is the governance body established by the UN Convention on the Law of the Sea to administer deep sea mining or activities related to the quote unquote area. So the deep seabed past areas of national jurisdiction. So the ISA, by the time that we wrote our article, had issued some, I think 29 exploration licenses, period. But 22 of the 29 were for the Pacific Island region, which is unsurprising, right? Because it is sort of our waters here in the Pacific that are so mineral rich in terms of the three main types of mineral deposits that countries and corporations alike are scrambling to access and to eventually mine from the seafloor, as well as from the hydrothermal vents and the seeps located in the benthic or deep sea environment. So yeah, 22 of the 29 were issued for this part of the region. I think 16 of the 22 were issued for the Clarion-Clipperton fracture zone, the main area of the Pacific where so much of this sort of activity historically has happened, leading to the sort of, you say, disproportionate or heavy concentration of these sort of coveted minerals in and around our waters. So that's sort of the backdrop. But yeah, when we wrote this, we had, in 2019, we'd already experienced nearly a decade, maybe not a decade, but like at least 7-8 years of straight sort of domination of the entire narrative surrounding deep sea mining by all the sort of cast of characters. Because deep sea mining is this, new global gold rush, where everyone's scrambling to access what many people suspect are staggering amounts of mineral wealth, to the tune of hundreds of billions of dollars. And so like the EU, for example, the European Union is one of the many players in this cast of characters, right? In this global story that's being told. And they, for example, gave, I think, over 4 million euros to the Secretariat of the Pacific Community to sort of expedite the process. They provided so-called model legal, legislative, and regulatory frameworks that they said were, fit for replication throughout the Pacific Island, throughout the Pacific Islands, to more or less sort of green light this industry. And so we had been, me and Julie and the rest of our team, and we have another team member who works with us here on the call, Klamiyamu Lalep, too, on various projects. And we had been through, after 7 years, it was enough, of just like attending meetings, being in conferences, all of which were like maddening, to say the least. And it was maddening and frustrating and pretty outrageous in some respects, because even the lawyers that were involved, because either they were involved because they had a vested interest, because they were supporting the corporation who was seeking to mine or to at least prospect an area, whether it's lawyers for Pacific Island states or lawyers for the ISA itself or the Secretary General Lodge of the ISA. We've just heard, who's also a lawyer, we've just heard this narrative, right? This story that deep sea mining is relatively low risk and lucrative. Those are all we know, right? And I was like, wow, that is a pair of very wild assumptions. Wild, spectacularly wild assumptions. And those assumptions are undergirding the entire early phase of this new extractive industry. We were told, for example, and we didn't get involved really like early on. I mean, we came in more as allies to the, we are Pacific based, but we really were acting in common cause with other groups like Fiji-based PANG. Actually, when we first met all those years ago, I think my first deep sea mining conversation actually was with Maureen Penjuli and Ralph Reganvanu in a hotel lobby in Berkeley, California, where the entire issue was brought to my attention. I was like, okay, maybe we need some additional lawyers to try to contest this narrative. Because, for example, what we were told from our allies, groups in the region, was that all the lawyers involved had really said things like, there's no room for conversation, or there's no need to pay any mind to other rules of international law. There was talk, for example, of different community groups in PNG and Papua New Guinea and other places who have sort of challenged these industries and how they've unfolded, for example, in PNG, and how it unfolded there. And community groups were routinely told by all the lawyers involved that they were like, I don't know what you're doing here. There's no place for that here. There is the right of free, prior, and informed consent that Indigenous peoples otherwise enjoy, and destructive, extractive industries. That's irrelevant. And it's irrelevant because this is all happening in the area. So it's all happening in this, like in the deep seabed past any one country's jurisdiction. Therefore, it's really irrelevant. We don't need to be worried about those things. And so we had heard sort of all of this we also saw, like I saw with my own eyes, various community groups and community activists who were rising to challenge this sort of green lit industry for moving forward. I saw them get almost mocked in certain settings. I remember being at another meeting with some ISA people and some other lawyers who were assisting the various groups who more or less were supporting this industry, even in the absence of scientific studies. And I saw that these activists were being mocked. They were saying, oh, none of their concerns are legitimate. These are lawyers and they know what they're talking about. So what we did, long story short, was like, nope, we came to help level the playing field. So Blue Ocean Law really tried to, we tried to publish multiple actual law articles in really credible, highly credible law articles in highly placed journals, widely read ones, just because we realized, okay, we need to challenge this narrative, and get them out in sort of the best possible manner. So our first one was the Harvard Environmental Law Review. The second one was Stanford Environmental Law Journal. And all of these articles really sort of clearly contested the dominant narrative around what laws do or do not apply with respect to this new extractive industry. So just to get down to some of the basics, we had argued in the latter, in second wave due diligence, the Stanford piece, that actually the entire narrative so far has been needlessly narrow. We believe that the ISA that has been operating under some a very exceedingly outdated notion of what constitutes the common heritage of mankind. So we made this argument quite explicitly. And then we backed it up with various things. We also talked about the development of the sort of the building out of the normative content of the concept of the norm of due diligence, and how it particularly has been really robust in the law of the sea context. We traced decisions from the various unclawed tribunals, which interpreted everything from fisheries to conservation, so we talked about many cases. I don't have to name them all here, but I mean, this is the bluefin case, and this is the other case with Australia, I think, and New Zealand suing Japan. I mean, there's just a bunch of unclawed tribunals, and they're a little bit boring, so we won't really go into all of them, and they're complex and nuanced. But basically, what we saw was a clear evolution and sort of jurisprudence, so to speak, coming out of these tribunals, where they were more willing to basically say, okay, this is, whereas the law of the sea and the way we sort of historically treated it was primarily preoccupied with very strictly fixed maritime boundaries and what states can do in or outside of them. But granted, that's still the case, but there has been room that has been made, room for an expansive concept of due diligence. The court was willing to read other things into the principles on precaution, the principle on avoidance of transboundary harm, and reading them into the general due diligence obligations. But most importantly, I think is Article 138, if I'm not mistaken. Article 138, right, commands the ISA in its governing of all these deep sea mining activities in the area. They still have to apply, quote unquote, other rules of international law. And we realized, okay, that's the key. That one line, other rules of international law. So we went meticulously through the other tribunals and actually found examples where the unclawed tribunals, for example, passing on an issue specifically like fishing, for example, overfishing, where they're reading as they have a specific case in front of them, but they're reading into, and they're construing that sentence quite broadly, other rules of international law. So meaning they're willing, these tribunals are willing to reach outside, reach beyond the text of the treaty itself. So they're not like, they don't necessarily only limit it to the, for example, the UNCLOS, which is the relevant treaty, right? The United Nations Convention on the Law of the Sea. They're willing to reach for other things like the Convention on Biological Diversity in one case. So what we saw these tribunals understanding that other rules of international law is a term that should be construed broadly, not narrowly. That means that all the other potential applicable rules of international law, not inherently in conflict with the UNCLOS, are allowed some breathing room. They're allowed to come in and inform our interpretation of what states' duties are, even in the area. So I was like, okay, so now we just need to stretch that one sort of bit further and say FPIC, this evolving norm of international law that respects the rights of indigenous peoples. One, because we understand that extractive industries in particular have had such disproportionate adverse impacts on indigenous peoples. And two, well, okay, I'll just stick with that one for now. But because of that, there's no need, there's no doctrinal bar, there's no obstacle truly from saying from pushing those norms even further and saying other rules of international law absolutely include like this expansive sense of due diligence, which should incorporate other rules such as the norm of free, prior, and informed consent. So our argument, of course, hinged on the fact that we don't believe international law is primarily preoccupied or concerned with in every case, with where activities are happening, but where their effects are felt. And we already know, at least from some of the activities, and we within the EEZs of Pacific Island states, Papua New Guinea, for example, and even the prospecting activities, so the pre-mining activities of the Nautilus Minerals, the Canadian company that's doing the activities in the water, have already sort of clearly and demonstrably disturbed the environment, the marine environment, and affected indigenous peoples in several coastal communities and their ability to practice and transmit to future generations their traditional customs, their customs and traditions in clear contravention of international law. So that was something really clear. So we took all of these arguments and we blended them together. There was several other like textual, when I say textual, I mean just like arguments based, anchored clearly in the text of the UNCLOS itself. For example, there was all this talk, in terms of like from several ISA people that, they were just, they would only focus on say Article 145, but not Article 146, which is really clearly about a concern for human communities and human groups. There's this tendency, especially in the legal narrative, to really have this whole thing disembodied. Like every aspect of the narrative and of this industry is disembodied. It's not connected. It's floating here in this stratosphere, but it's not connected to human beings organized in human communities in nation states, that have all of these obligations, and we are only in the pre-mining phase now. And yes, a lot of the things that we found were actually about harms that are harms that indigenous peoples reporting from mining activities within the EEZs, but there is nothing to stop precisely because we really don't know. And when I say we don't know, scientists don't know. Like Venus, Mars, and have both been like mapped in greater detail than the deep sea. There's so much that scientists have conceded we don't know about the benthic or the deep sea environment, that the precautionary principle and everything else really militates strongly in favor of not making certain arguments. And I think the precautionary principle really precludes the argument that, that FPIC wouldn't be implicated because these things are happening further afield. They're happening further out. They're areas beyond national jurisdiction. We simply don't know. We don't know exactly like how deep sea mining is going to affect even pelagic species, is going to affect the tuna and other species. And we don't know how just sort of transboundary that harm will be. And so like we basically just tried to make sort of doctrinal room for these arguments and largely just contest the way the ISA and some of the proponents of DSM as an industry have sort of wrongly framed or at least under-examined the issue and sort of prejudged the issue, legally speaking, as if there's nothing, there are no other norms of international law that can be called upon or that have something to say to the norms of international law that govern the ISA and its governing of deep sea mining activities in the area. So that's sort of some of the work that we did. And so we thought it was really important to do it as a team just because that's really important. I mean, Indigenous peoples, the last thing I'll say before Julie takes over with some more specifics, but just Indigenous peoples in this region, you know, have already seen this. We already know exactly what it is for, you know, outsiders to come in and sort of experiment. You know, like this, the Pacific region has already been a site of experimentation. And I think clearly we're done with that. I think that is part of a bygone era, and we have to challenge it tooth and nail every step of the way if another industry is going to come, including our own, and that may include challenging our own states, to be clear, right? Challenging our own governments, who are also some of which have greenlit the industry with sort of like without sufficient attention paid to like really meaningful community consultations, let alone free prior informed consent. So yeah, so that's sort of where we are in the backdrop and some of what we argued in second wave due diligence. And we just tried our best to be good, you know, allies in the region and have just an alternative perspective offer that had enough sort of textual and sort of historical and legal basis. So we made those arguments. So yeah, I'll turn it over to Julie.
Great, thanks Julian, and thanks Maureen and Joey, and the whole team at PANG. It's great to be here, and it's great to be speaking with all of you about deep sea mining and some of the issues that Julian has raised. I'll just try to fill in a little bit on some of the sort of science and practical aspects around deep sea mining, some of the trends and shifts that we've seen in terms of how the industry narrative has evolved somewhat since we were doing the initial research, and then just kind of highlight a few the sort of policy elements that we've just found to be the sort of most pertinent when doing this work. So as mentioned, my name is Julie Hunter. I'm a human rights lawyer. I've been working with Julian at Blue Ocean Law for the past 6 or 7 years or so on a number of different human rights issues in the Pacific, including resource governance, self-determination, deep sea mining, climate change, and others. And we've seen there's really a lot of intersections on all these issues. So when we first started working on deep sea mining, I think the self-determination issues, some of these issues of sovereignty over natural resources, consultation and consent provisions, that was more clear, but we didn't necessarily think there was a climate link, or it wasn't immediately obvious, because really, as Julian was saying, the knowledge of the deep seabed was so scarce and is still so minimal that there wasn't much science about it. But as we were working on it, and actually during the release of our first report, there were new studies that came out actually looking at the deep seabed hydrothermal vents and their links to climate change, particularly in terms of being potential carbon and methane sinks, which I'll get to in a second. So in the course of doing this work, a lot has changed. One good thing, or silver lining, as we've been monitoring the industry, is that it's relatively slow moving compared to other areas of resource extraction. So while there's this total scramble and sort of gold rush activity and mentality and buying up of licenses and these sorts of things, the actual technology is untested and new and expensive. So companies require a lot of initial investment to move into this area. And up until recently, it wasn't really economically viable, because we've known about seabed minerals on the ocean floor for probably about the last 60 or 70 years when they were first discovered. And that was one of the first things we learned about the ocean floor, and not much else on the science side, just that there were minerals down there. So we didn't know about the types of ecosystems and the type of organisms and the biodiversity of those ecosystems. We just knew that there were minerals. And a lot of the seabed mining international regulatory regime just emerged from that small piece of knowledge that there were minerals on the seabed floor, and that we should sort of divide them up to make them the common heritage of mankind. But at the time, it wasn't really recognized that there were maybe much greater common benefits for humanity, including potential medical or human health related research that could be done around hydrothermal vents, these climate functions that I mentioned of the deep seabed, the types of very diverse organisms and thriving ecosystems that exist down there, all of which has come out relatively recently. But because it was too expensive to really do a lot of deep sea exploration, much less extraction, the industry never really got going until recently, when things have now shifted, partly because of the rising value of minerals globally. And a lot of that has been driven by, just increased demand for minerals, especially among emerging powers like China, but also renewables, which use a lot of metals, rare earth metals, also consumer tech, computers, laptops, smartphones. So really a lot of the new technology of the 21st century is now driving this huge increase in demand for minerals. And at the same time, mining technology has become less expensive. So it's become more economically viable to pursue seabed mining, and increasingly more companies are looking into it. I mean, they tend to be, I think, more kind of hedge fund funded, you know, in the sort of innovative space. So there's not a ton of them, but there's enough that they're looking to pioneer this new area, and, you know, seeking finance and investments. So just to give a quick overview of how, you know, seabed mining is proposed to work. I mean, basically the idea is to extract numerous different types of metals from either nodules that are located on the seabed floor or areas around either active or defunct hydrothermal vents, depending. And there's different methods where you would either scoop them up or drill down and extract them. It's quite deep. It's between 400 to 6,000 meters down, so typically 1 to 4 miles below the surface of the ocean. And the general argument, as Julian was saying, was that industry's basically been saying that this is pretty low impact or relatively safe, but they really don't have much knowledge to base that on because this is a pretty unknown environment. They've still continued to make those arguments, and they often really like comparing seabed mining to onshore mining and saying that seabed mining is just bound to be far less destructive. It will be better for human rights. It's just the ocean, so who cares? And I think these are arguments that tend to be made about environments that we don't understand very well. So part of our work in our initial research looking at regulatory frameworks in the Pacific that were aiming to regulate seabed mining, but also doing interviews and doing field work on the ground in places like PNG, Tonga, and Fiji, where there was sort of early exploratory mining and seabed activity already happening, was documenting already existing impacts just from those exploration activities and just from the drilling that was occurring, let's say 18 feet into the seabed and not deeper. That was really just exploratory, and actual seabed mining would go much deeper than that. And what we found in our research was that there were significant impacts already at that stage, that there were reports of marine animals washing up, deep sea animals that were hot to the touch, washing up on shore, cloudy areas of reefs, and in PNG in particular, sharks had left the waters, and all these traditional indigenous practices around shark calling could no longer be performed because the fisheries were affected. And this particular area of PNG, where a lot of the first sort of exploratory mine was planned, is an extremely biodiverse area, a huge fishery, a tuna spawning ground, a migratory channel. It was really possibly one of the worst locations where you could choose to have, sort of an initial totally experimental technological extractive endeavor. And, as we've learned more about hydrothermal vents, and not just hydrothermal vent systems, but other seabed ecosystems, we just increasingly learn about their uniqueness and their potential value apart from mineral wealth, which includes, hundreds of undocumented, totally different micro and large scale organisms that live in dark, that have adapted using chemosynthesis, that are able to live in the hottest temperatures on the planet. There's actually thriving tube worms, snails, octopi, many other different types of species, but they're already going extinct due to some of this exploratory activity before we've even had a chance to document them. And we haven't been able to do even baseline studies to catalog what's there before we destroy it, which is another easy way for industry to kind of say nothing happened because we didn't know that these were there and now they're gone. So that is coming out increasingly. And as I said, there's some evidence that there's medical implications for the types of organisms and the concentration of chemicals and such coming out of the hydrothermal vents. But what we found in the course of doing our research was that actually an article came out right after we released our first report, Resource Roulette, which was documenting the impacts on islanders and the sort of opposite of precautionary legal frameworks that were being pushed onto Pacific Island countries in order to fast track mining and to allow for kind of commercial contracts to be signed. And this academic study came out, I think authored by 16 or 20 different oceanic experts, that basically said that hydrothermal vents have methane seeps, which are large buildups of microorganisms that essentially sequester methane and carbon, and that if those were to be destroyed, it would be a cataclysmic doomsday event. And that coming out right after we released our report was, to me, just more evidence of why the precautionary principle is so important and why it should really be the dominant kind of guiding principle of governments and regulators, not a scramble for wealth. But I think the narrative around a sort of frontier mentality, sort of innovation and gold rush type ideas is still quite powerful. And if you argue to, just sit back and not do anything, it tends to be less convincing, to many different parties. So we were looking at what types of arguments we can make. And as Julian was saying, there's a lot of international legal arguments outside of the very narrow framework that the ISA has developed. In addition to FPIC and consultation and other principles from maritime law and sort of environmental law, there's also basic international human rights law, which is really primal in that, you cannot violate it, and all international law has to abide by international human rights law, especially fundamental, universal, agreed upon laws. And that can be the right to life, the right to work, the right to food, the right to a clean environment, all of which we found were actually impacted by deep sea mining. And even if it's located out at sea, that actually doesn't matter, because the impacts will be felt on land primarily by islanders and primarily by people in the Pacific and primarily by indigenous people in many cases. So if it's impacting through pollution or a number of other negative impacts people's human rights, then international human rights law is also activated and should really be dominant. So basically, we've made these arguments. We highlighted the climate aspect as a real example of why you can't just jump into things blind and say, well, because we don't know anything about this, it must be safe. We say, no, because you don't know anything about this, you can't do it, because it's most likely not safe. And it's much easier to show that something's more likely to be unsafe than to prove that it is definitively safe, that it won't have any adverse impacts, especially on marginalized or vulnerable groups who need additional protection and who receive additional protection under international law. So I think the industry is to some degree realized this, and it's been interesting to see it in real time because of the great work of a lot of civil society and activist groups throughout the Pacific. I think that was really instrumental in pushing back against Nautilus, the Canadian company that was doing exploratory mining in PNG's waters. Unfortunately, the whole project was kind of a disaster, and financially, PNG is now in debt to the tune of $120 million as a joint investor in that project after Nautilus pulled out and protected their own financial interests, which is another bit of a cautionary tale in terms of partnering with multinational companies on very experimental, high-risk, extractive activities. And I think that's also common to mining regimes in general and the history of mining in the region, and really in almost all regions, where the multinational company in most cases, comes in, extracts the resources, makes most of the profit, and leaves the government and the people with, in many cases, environmental disasters and bills and health effects. And this is the case with many land mines in the Pacific. And it's, the argument that there will be revenue that comes from this, even if it's a small amount of tax revenue that often induces governments to sign on. But it's very difficult, especially for smaller governments, to really regulate these powerful companies, especially when they're doing work out at sea. and offloading the minerals at sea where they never even come on shore. The economic benefits in terms of jobs are actually very minimal because it's very specific jobs for people in the industry. And then, basically once the minerals are gone, the wealth is exported, and maybe the government sees 1% of revenue or less because companies can underreport their mineral take without any oversight. So it's really hard to see much value in terms of the economic benefits, while at the same time, what you're potentially left with are the actual acknowledged impacts of deep sea mining, which include pollution, heavy metals in the water, tailings, death of large mammals due to the noise and light pollution, likely contamination of the food chain, acidification of reefs, and potential for oil spills on the surface because of increased traffic, and all these other sorts of impacts which the industry does acknowledge. So in terms of the actual benefits, I think unfortunately governments are continually still sort of attracted to the idea that they could have an independent source of revenue that it would provide for the future, whereas in the reality they might be left with $100 million of damage. But even more worrisome, the destruction of potential carbon sinks, and who knows what that would do to fisheries, who knows what that would do to global climate in addition. So as I said, the pushback from activist groups did, I think, help in getting Nautilus out of PNG and really pushing back on this idea that it's okay to experiment on people in the Pacific and in their waters and on their resources. But these plans still continue to move forward. The ISA is still signing and issuing licenses. And now the framing has shifted somewhat. And like I said, I think Nautilus has somewhat disbanded and formed, but some of those same actors have now reformed in companies like Deep Green Metals. And the incorporation of just the term green in the name kind of gives you a sense of how they might be redoing their branding. And I just wanted to share my screen and show a few screenshots of Deep Green's website, because I think they're interesting. And kind of, when I first saw this, I was actually shocked because I haven't seen this level of co-optation in the mining sector yet. So I think they're being smart and crafty in terms of actually shaping their narrative now around renewables. And they're saying that they're part of the solution for climate change, that they're part of the climate justice movement. If you can see, their vision is a zero carbon circular economy. And to get there, they will source metals with the least environmental and societal impact, then move to mineral recycling. And as I said, I mean, this argument that offshore mining and seabed mining is safer than onshore mining is, one, a bit of a farce because the impacts are significant and severe. And second, there's also no likelihood or evidence that offshore mining will replace onshore mining. It will just add to onshore mining. So instead of having only offshore mining and no onshore mining, we'll just have both, with the continued and probably exponential increase in the race to extract all of these ultimately unsustainable and non-renewable resources from the planet. But they can say this, and then they can say they're going to move to mineral recycling, and there's nobody to really hold them to it. But of course, what we would advocate is a moratorium on deep sea mining, and don't go there in the first place and leave a big mess and then say you're going to move to some form of recycling, which is another general thing that industry likes to say. Maybe look at doing things like landfill mining in the first place, and not ruining entirely pristine, important ecosystems that we don't fully understand. So you can see just a few more. They're really emphasizing their multifaceted approach of meeting energy needs, supplying renewables, even though there's no evidence that they would supply majority of their minerals to renewable companies. And then, this real marketing approach. And I think it's going to be difficult to push back on that because renewables are a big growing industry. And there's this real competition for metals now. There's geopolitical issues, with China owning most of the world's rare earth metals, and countries like Japan trying to have their own rare earth metal supply, including from their own waters, which Japan is actually, I think, was the first country to successfully mine their own waters. And activists and civil society needs to just be increasingly nimble and being able to push back against these types of efforts, because it's just a real tried and true tactic of industry, and it often works. And you can see it just had an example here in how Coke basically co-opted the actual terminology that health advocates were using, and pollution advocates, to push back against plastic pollution. And they sort of took those terms, co-opted them, flooded the airwaves with their own message, basically killed the movement, and at the same time, this has not changed any of their actual fundamental practices. So yeah, I think it's an ongoing challenge, and I would very much welcome everybody's thoughts and questions on how to address these issues moving forward. I think from both a legal perspective and a policy perspective and an activism perspective, there's needs to have more sophisticated methods to get back at always powerful actors pushing initiatives that are really not going to be good for the majority of communities and the majority of people who will be the most impacted. And I think with the kind of impetus and growing funding and support around climate justice and climate change movements, that is probably one of the biggest opportunities to halt this in its tracks. But it does require a complete shift in the way business is done and the way governments operate, which will be a bigger challenge. So just increasingly cutting through the false narrative and supplying, I think, a true one based on people's best interests, human rights, and really the welfare of communities and the species as a whole in the long term will be our best approach. So I'll just stop there, and happy to have some discussion and answer any questions. Thank you.
Thank you, Julian and Julie, for just really walking us through a little bit of some of the body of work that we've done with Blue Ocean Law. And I think, Julian, it's really a decade now since we've been in the trenches trying to understand this new frontier issue, both in terms of the narrative framing and the kind of responses, the complexities of responses, because it's both legal, economic, political in its intentions, and how they completely ignore Indigenous peoples, and for a while now. I think we've made significant gains in terms of arresting and slowing down deep sea mining within our EEZs. But I think we need to do more, given the way industry is morphing itself, and their narratives are now presented as part of a solution. And the solution comes at great sacrifice. And I think it's really useful to have you both come back and join us on the map to revisit this body of work that we've done together, and really do we need to go from here. I see that there's a question from Deborah. Deborah, could I just ask you to ask your question instead of making me read it to kickstart? And if others could just raise your hand if you would like to ask questions at this time. Deborah?
Hi, sure. This was just a question that crossed my mind as we were talking about state liability, but I'm curious, since the question of a moratorium came up or a ban, that if a state is, currently contracting while they decide on the moratorium, like, have you discovered any aspects of contract law that would hold the state liable, not for environmental harm, as you mentioned, but somehow liable to these private mining contractors that they have entered into contract with, like that burden of state liability I guess I'm just wondering if like there could be some sort of financial disincentive for a moratorium.
I'll take that. Deborah, thank you so much for the question. I think that's an absolute absolute threshold issue that various legal counsels for the various countries would have to answer. So I mean, me as a US trained lawyer and Guam being a US colony, so I'll answer from an American perspective, so to speak. Yeah, the relevant legal consideration in a US context would be the contracts clause of the US Constitution, which of course in Guam's case, which was reproduced here in our own local version of the contracts clause. And that basically precludes the lawmaking entities of like a state, like, for example, a state legislature from passing any sort of legislation that would then upset already vested contractual rights. So I think that's the analogous thing. So we would have to, lawyers for whoever the state happens to be, would have to understand if there's an equivalent, for example, to a contracts clause in the various states' constitutions, because the constitutions are always the primary legal document. So you would check that first. And if there's any functional equivalent, or you would check purely as a matter of contractual law and the freedom to contract, you would check the actual underlying agreements executed bilaterally between the country and the corporation, because I'm sure, I mean, and that's part of the problem. Like, I mean, I haven't reviewed any, but I suspect that it's the corporations using their templates as using their model, right? Clearly only favoring one side of the transaction as the template for the Pacific Island state. It's not like PI states have an abundance of these templates. For example, we know that already, and I can already say that even without knowing, because even the mining codes, for example, the legal frameworks have been stretched beyond their actual original purpose. So some of the actual laws used to governing mining, marine-based mining, actually are taken from terrestrial mining codes, which are obviously inappropriate for that. So that's going to be an absolute threshold legal consideration that every Pacific Island country that's even considering any such call for moratorium would have to figure out, because obviously it wouldn't be about unwinding the transaction. It will be figuring out what sort of constitutional or statutory provision would be potentially violated in light of the changed position of the state. So to answer your question, I don't know all of the constitutions for all these Pacific Island states, but I'm sure in-house counsel will be able to walk their individual states through that. And they absolutely have to do that to make sure that it's as carefully done as possible. But that just goes to show that we sort of would suggest that before PI states engage or sign these agreements, that they would actually have in-house counsel to make sure that they're not just accepting a template from the contractor.
Thank
Sorry,
you.
did that help you, Deborah?
Yeah, and that's so interesting, because your answer is basically that this would have to happen on a state level. This isn't part of your international law coverage. It enters in due diligence. Like, it's going to be different for every state, and it's probably not already articulated. Is that right?
Yeah, that's mostly right, because oftentimes we have these international laws that float out here, but they still have to really implement it through through domestic legal frameworks too, so that they are incorporating those norms, because that's what happens. And then you further, the lawmaking body of the country further fleshes out the specifics. And that's the thing, Deborah, too, like the devil's always in the details. Like, it's always, and if we go, can I just go real off the wall here? Sorry, I'm kind of feeling this now. I'm really in this conversation, and I really want to take this further. I think, Maureen, something that you said actually is interesting, because I think what happens is there's this rush there's almost like we are so almost instinctively, we are so quick to move immediately to either the corporation to figure out what they're doing wrong or what nefarious thing, or to move to the country to figure out. But there's another player involved, and it's the ISA, and we give them way too much room. The ISA has really sort of not faithfully executed their mandate, in my opinion. There's just no one on earth who could ever convince me that the ISA is faithfully discharging their duties. Can I give you really specific examples? Sorry, this is more than you've asked, but I want to give it. Is that okay with everyone? Okay, I assume. Okay. Okay. So although I want to read you guys a tiny excerpt from our report, just so you can see when I say that the devil's in the details, I really want to walk you through this scenario. Okay. I'll just read you this passage. Although developing rules and regulations to ensure that deep sea mining activities do not harm the marine and human environments is one of the ISA's chief regulatory functions, it appears the ISA has not been generally faithful to this mandate. For instance, many of the mineral specific regulations issued by the ISA to date have qualified the duty to prevent harm to the marine environment enshrined in the UN Convention on the Law of the Sea. To take one example, regulations adopted in 2000 to govern the harvesting of polymetallic nodules, one type of deep sea mineral deposit, while paying lip service to the duty to protect the marine environment, further provide that DSM contractors shall take measures to prevent, reduce, and control pollution and other hazards to the marine environment arising from its activities in the area, quote, as far as reasonably possible using the best technology available. This language signals, this is just me now talking, this language absolutely signals a retreat from the terms of the treaty itself and its clear intent, which is to protect the marine environment, as no such qualifying language appears in the treaty, neither in Article 45 or Article 46 of Part 11. And of the Law of the Sea. So we have these general things that are floating out here, right? Like this governing framework and this body, but this body's empowered to regulations that should do one thing, but they're doing another. And if you read those regulations, and that's what you have to do, it's sort of like tedious drudgery, it's like tedious work, but you have to read through there and really figuring out that the ISA is constantly lowering the bar for the private party, constantly. And it's even doing things like creating a list. There's another set of regulations that create a list where the X, Y, and Z type of activity is presumptively, legally speaking, there's a presumption that those things will not harm the environment. Who does that? Who creates a list of things that say, oh, all 25 things on this list, we're going to presume that this has no harm to the marine environment? This is the precise opposite of ISA's job. Does that make sense to you, everyone?
Yeah, actually, if I can just add.
Yeah, go ahead, Julie.
Yeah, I just wanted to add also generally that mining companies, extractive companies often have a track record of suing governments and countries that back out of contracts or mining agreements. So especially in cases where there's environmental pushback or community opposition, and then the government changes its mind, or even if it's not the government directly, the company will often try to enforce a contract through arbitration tribunals or by suing the government directly or however, and they tend to win big settlements doing that. So they definitely have the contract law down pat, and have in many cases stacked resources and many lawyers on their side to help them in these legal battles, which is why it's often really damaging for especially developing countries to undertake these types of agreements, especially when either they'll end up with huge environmental damage in many cases, or they'll end up having to pay the mining company actually to not pursue the activity. So I think, as Julian is saying, it is really down to the individual country jurisdiction, but I think there's a big liability and a big financial risk for governments taking this on.
Maureen, you were going to say something too.
Hi. Yeah, so I can see that Duncan has his hand up. So Duncan, the floor is yours. Duncan?
Just trying to unmute. Thanks, Maureen, and thanks for the two great presentations. In the BB&J negotiations for the conservation of marine biodiversity in ABNJ, there's been a lot of support, well, there's a lot of support for traditional knowledge in the context of the treaty as a whole, which spans everything from area-based management, marine protected areas, environmental impact assessments to marine genetic resources. Some commonly given examples looks to things like migratory fish, such as tuna, traditional knowledge about those migration patterns, and of course, Julie mentioned marine resources, marine genetic resources, which are other good examples. So in the context of general international law suggested, like by Julian as importing that through Article 138, for example, can either Julie or Julian point to other examples of the incorporation of traditional knowledge and Indigenous rights in current practice, I guess either in relation to areas beyond national jurisdiction, but also I think relevantly looking at mining within national jurisdiction. Thanks.
Julie?
Yeah, Duncan, could you sort of repeat the last part of the question?
Yeah, sure, Julian. I'm looking for some examples and like international practice, looking at, for example, the Convention on Indigenous Rights, for example, or the Declaration rather on Indigenous Rights, perhaps, but other places that you can draw on for the application of either traditional knowledge specifically or Indigenous rights, prior informed consent, and so on, applicable, firstly to the areas beyond national jurisdiction, such as the area that we're talking about, or perhaps it may be equally useful to draw on national examples, maybe from PNG, for example, applicable to mining with inshore, either terrestrial mining or inshore mining.
Yeah, Julie, do you want to go first or me?
Yeah, you can go ahead.
Okay, I don't have a great answer, Duncan, only because we like a lot of the things that we pull on are not specifically about, or they're not really about areas beyond national jurisdiction. So that's part of what we're doing in the articles. We're really stretching it to this sort of fact pattern. But there are other examples, for example, when they're, I think it's the basically the jurisprudence, the various decisions that come out of the treaty bodies, for like the UN Human Rights Committee, even the Inter-American Court of Human Rights, and even CERD, actually, Committee on the Elimination of Racial Discrimination. A lot of times what's happening, it's an indigenous group against a state. And so what these treaty bodies have been managed to do is they're stretching it. We've seen a stretch over time in the jurisprudence of those bodies. For example, there was one case involving an indigenous group in Suriname. This was before the Committee on the Elimination of Racial Discrimination, and there was a subtext of an issue, and that issue was because the actual mineral resources at issue in that case were not technically, the indigenous peoples didn't technically own the resources, at least underneath a certain point in the ground. These are subterranean mineral resources, and the court was sort of like sidestepped that issue. I mean, the treaty body sidestepped the issue and sort of was they were not actually concerned with the technical issue of ownership, but they still incorporated it and applied FPIC in the context of that sort of mineral dispute, even in the absence of like even in the absence of the issue of ownership being settled. So I think that's a good example of where we see like some stretch and some of that in some of these areas of law, but definitely we have not seen like for example, the Seabed disputes chamber thing, where that was a really good case for due diligence. That was not, that was in the area and that was good, but that obviously wasn't FPIC related. So none of these the things that we've seen are like FPIC related, except for some of these treaty body things like CERD, for example. The rest have not been. But yeah, so we're just making this argument basically with the sort of underlying assumption that there's no doctrinal obstacle to making an FPIC related argument for areas beyond national jurisdiction. That's not a great answer, but only because we don't know. I don't have more examples. Julie, can you think of anything?
Yeah, not really. I mean, I think partly because this is just a very new area still. So to my knowledge, it's not something that's been incorporated in a lot of hard international law to date. And then state practice, I think it is increasingly being alluded to, if not incorporated, especially in countries where there's stronger protections for indigenous peoples, but that is primarily within national jurisdictions. And actually, Clement, I don't know if Clement might know more about the areas beyond national jurisdiction and some of the negotiation processes for the new treaties. But I do hope and think that this will hopefully become a bigger area where you will see this language, traditional knowledge, FPIC, indigenous rights being taken into account, not only for national laws or laws that implicate, country jurisdictions, but also for global commons and the area and these areas beyond national jurisdiction. So we'll see, but yeah, I would be curious to hear from anybody else if anybody knows more as well.
Clement, if you feel free to jump in on that, the question from Duncan. But I think that the other key trend that we're seeing in terms of FPIC and its application in relation to law is really in the financial institutions. So we're seeing the World Bank really seriously starting to look at FPIC. And again, I think this is this kind of stretch where we need to look and see where it's really being applied. And I think the banks, the financial institutions, the World Bank, Asian Development Bank, are increasingly having to look at FPIC and taking it seriously within their kinds of mechanisms for redress for Indigenous people. So I think it's still a body of work where we're seeing this push to really realize FPIC more than just what we're saying now. So I think those are some trends where we're seeing its application.
Yeah.
In a good way, we're seeing it.
Sorry, Maureen. But yeah, in terms of other bodies, there's definitely been like guidelines and issues, not just a World Bank too. I think, is it called Equator Principles? Do you remember that? Is anyone familiar with that? It is about it's a huge organization of financial institutions. I think 94 total, but in several countries, and they have a whole sort of thing whenever they have development projects. So they have an FPIC manual, so does UN, the RED program, the Food and Agricultural Organization of the UN also has an authoritative manual on FPIC, and none of that is like, oh, that's all these innovations. More and more of these entities are creating FPIC sort of manuals, so to speak, or guidelines at least, when they have dealings with Indigenous peoples. But yeah, no, that's a great question. And I think we need to keep looking at that and finding more examples.
Clement, I see your hand.
He told me earlier he may have to leave earlier. Maybe he had to step away to be on another call. So I don't think...
Hi, hello everyone. I'm still here.
Okay, great.
Yes, thank you very much to the organizers for arranging this. And thanks as well to Julie and Julian for, I thought, really fantastic presentations on the work that you and colleagues have done in this area. So going to Duncan's question. Hi, Duncan. So in addition to the work that we're doing in the BBNJ negotiations to recognize the relevant traditional knowledge of Indigenous peoples and local communities, there is ongoing work already under the CBD, the Convention on Biological Diversity, especially for the description of ecologically or biologically significant areas or marine areas, or EBSAs, many of which stretch into the high seas or areas beyond national jurisdiction. And the process for describing those EBSAs involves, among other things, reaching out to holders of relevant traditional knowledge, Indigenous peoples and local communities, to ask them to participate in those processes. And so these EBSAs, once described, could be impacted or could play a factor in future deep seabed mining activities in the area as we try to figure out how to put everything together. And it should be noted that the CBD itself, the instrument itself, does reference Indigenous rights, a kind of a catch-all provision. So that's one way you can bring in, among other things, free, prior, and informed consent. And there's ongoing work in the Arctic. You have the Central Arctic Ocean Fisheries Agreement, which is focused on fisheries, but it's also taking a more expansive view on the potential impacts of climate change and other human activities on the Central Arctic. And Arctic Indigenous peoples are very active in that space. And there is a recognition of UNDRIP, the UN Declaration on the Rights of Indigenous Peoples, in that agreement. And the Canadian government in recent years has expressed an openness to consider potential impacts on Indigenous peoples from deep seabed mining activities that take place in the Arctic. So there are some things going on right now. How they all fit in together, I guess that's why we have lawyers like Julian and Julie to figure all of that out. Thanks.
Thank you so much.
Any further questions? Can't seem to see any hands. Comments? And if there aren't, I see one hand. Could you just please unmute and speak? I see two. Claire and then Calvary. So if you could just take both questions and then get Julian and Julie to respond. Thank you. Claire?
Sorry, thank you firstly to Julian and to Julie for excellent presentations. And I'm really sorry that I came in a little late, Julian, to your presentations. I didn't hear it from the beginning. I'm interested in, because we've got a campaign and we're really trying to stop seabed mining, how we can pull out all stops and work in, different what do you say, aspects of challenging, and I'm very interested in like Deep Green and how, not interested in, I'm just appalled by how they, market themselves, how they've rebranded themselves as really kind of savior of the planet kind of thing. And, so the challenges in that dimension, but there's also, because of your legal expertise, beyond what you're doing now, which is really important, what you're doing, but there's ways in which they're moving that I wonder whether or not there's other ways in which one can use the law to challenge them. So for instance, Deep Green has just merged or been acquired by what's called a special purpose, what do they call them? SPAC, special purpose acquisition company or corporation. This is just a very recent development, like 4th of March, they announced it. And that particular body is called COAC, and it stands for, SOAC, Sustainable Opportunities Acquisitions Corporation. And this is in order to enable them to be listed on the New York Stock Exchange and to, basically build up their investment capital for this big enterprise. But, bearing in mind what the three Mine Watch organizations said in the report, Why the Rush, which is what, where they said that basically these companies, they're talking about both Nautilus and Deep Green, are miners of, capital. Yeah. This whole thing looks really pretty fishy and shady to me. And I'm just wondering how one can, for instance, investigate the law around investment and stuff, and whether these guys are just doing some really shady stuff here to undermine, if you like, their credibility as a so-called mining, as a mining company. They actually are trying to rebrand themselves too as a transition company. Jared Barron, as you probably know, says, we're not really a mining company here. And just so many kind of contradictions in what they say and then how they subsequently say what they're doing. So they're now talking about they're a metals production company. Earlier, they were saying they're just bringing the metals, the battery in the rock, the PMNs to the surface, and somebody else's, some third world country or whatever is going to be extracting them and whatever. You're keeping up with them and what they're saying they're doing and what they're intending to do, and I just don't trust them at all. And yet they're being taken very seriously by ISA, and by the Pacific Island states that have been sponsoring states for them. So I'm just wondering whether or not there's ways in which one can kind of just look very critically at these new developments in terms of their investment, the merger, for instance, and how they're seeing they're going to go from here, because it's all being, represented too as a, what do they call it, an environment, social, and governance focused merger, right? And that just needs so much unpacking. I've just been looking at it because I stumbled upon this thing last week, but I think we need to kind of undermine them, or show them, expose them for what they are. So just wanted to see whether or not you had anything to say about that.
Can I ask Calvi to come in at this point, and then Julian and Julie to respond to both sets of questions, please?
Hello, everyone. Sorry, I mistakenly clicked my raise of hand, but anyways, I have maybe just two questions, if I may. The first one is just to get your views in relation to what would be your definition for indigenous people in the context of a country that has a hybrid kind of a legal system, where on one hand there's a state legal system and the other hand there's the customary legal system. I just wanted to get some views on what would be your definition, noting the existence of two legal systems per se. The second one is in relation to the application of FPIC itself, in relation to compensation. You know, I'm referring particularly mostly to the national level. I'm just curious of how FPIC would be applied when there is need for compensation, noting that should there be damages or so forth to the customs and so forth, or societal values of local indigenous people, how would FPIC apply in the context of compensation? Thank you.
Julie, do you want to start first, and then I'll just add on?
Sure. Yeah, I think, thank you, Claire and Calvi. These are both really good questions. So I'll start first with Claire's question around strategies for addressing deep green and these types of industry strategies, and the financial sort of investment aspects, I think, is not necessarily our area of expertise. I think kind of what the work might call for is not necessarily, I mean, I think there could be more of a sort of legal investigative approach taken in terms of looking into the finances and tracing those flows. I think that could be the work of human rights lawyers, or it could be the work of investigative journalists or civil society activists and defenders who just can follow money trails. And when we were looking a little bit into some of the funding and when funders were pulling out of Nautilus, you know, they do have a lot of public documents where you can find this information. So it should be possible to try to trace the financial flows and to figure out more information there. But I think some of the most effective work is really around building these counter narrative campaigns and just kind of highlighting the issue, bringing it to public attention, publishing news articles, op-eds, and working with journalists if possible to have the sort of broad-based coalition where you can sort of stop their narrative in its tracks and challenge it at an early stage and continue to do so. And there are groups in Mining Watch and other types of NGOs that are very good at doing this work already. I think if you're not in touch with them, I recommend reaching out to a lot of the groups that do work on these issues, and they follow these companies, and they're actually pretty on top of their kind of evolutions. So that's probably where I would start. But I do think that the overall approach really needs to be this big, multifaceted, coalition-based, social movement-oriented, just kind of strategy to counter what is a lot of money and resources, you know, pushing these initiatives, and that are not trying to stop them or have them be slowed down in any way. So you have to really build up a lot of attention on the other side. But once it's there, and I think, you know, even just activating some high profile climate figures, you know, Greta Thunberg or other people to come in on the question of deep sea mining and to look at companies that are arguing for renewables and sustainability, but are just really greenwashing and co-opting the narrative, that then it will either force them to change, or, you know, there will just be more investigation by multiple actors, and then you might be able to get government actors and other regulators involved as well. So that's all I can say on that. I don't know if Julian, if you want to add to that, or maybe address Calvi's question.
Sure. Yeah, I'll try my best. But just taking the question from the different angle, though, to the person who asked it, is, you know, it's also incumbent upon lawyers and the legal community just to be more innovative, to be more creative. Like, I mean, there definitely is an enlarged role that lawyers can play that we just haven't. I mean, for example, us and our team, we don't have the bandwidth currently to do things that are clearly more adversarial, but those are absolutely on the table. Like, you know, no one's really looked at them yet, it seems like. I mean, we have nonprofits who've considered things, but we definitely, you know, for example, a legal team could come in and support like the people of like Tembin or Messi or Kontu or just these villages in Papua New Guinea and support these communities who have already sort of challenged and so expressed their vehement opposition to it. They could just be supported by lawyers who could sue theoretically on a theory of trespass to land. That's like just like very colorful sort of like claim, you know, I mean, and it may include, for example, in some cases, like that case may include a claim against your own government, or, you know, or bringing like a claim or filing a claim. I mean, people just, I think Torres Strait Islanders just recently did an international filing based on some other aspect, I think, of climate. But the point is, you know, there's definitely filings that can be made, submissions that can be made, whether it's really, really soft law, like, you know, submissions filed to the UN Special Rapporteur on the Rights of Indigenous Peoples, or the Human Rights and the Environment. You know, these are, and then those entities can in turn send allegation letters to the relevant state party, right, to the relevant government. You know, those are just things that are underutilized. But even just from a straight up classic adversarial, like A versus B, like, you know, kind of like two parties on the side of a versus, like that's what we can do too. Like people can just sue corporations or companies on trespass theories or other theories, you know, for the basically the idea that yes, it's even happening in water, but it's trespassing and affecting us and enjoyment of our rights in our traditional LTR, our lands, territories, and resources. So those are like things that could happen, you know, like a group of customary landers who could get together. So like our allies and outsiders can be supportive in a few ways. One, they can do more listening and less talking. I mean, just get a better sense of like what the communities on the ground really need. Because oftentimes, like I have even been in a room with funders, and wow, it's like the funders talk as if the people aren't even in the room. But like people oftentimes, they're very smart and they know already what they want or what they need. And like I've seen some of these groups go to funders and funders give them answers that are like spectacularly non-responsive. Like that's not at all what the community is asking for. So we don't know. So one, listen, to take the cue from the community groups themselves, who oftentimes have their own voice and clearly articulated demands, and figure out what useful way like you can support that sort of community group. Another option, God, I have lots of like random ideas now, but like ideas like, for example, there could be like a deep sea mining like summit, but it's the opposite of a corporation summit. Because, you know, like annually these corporations get together, they have this really fancy buffet, this like huge event. But imagine if there was like a people summit that came together in DSM and all the coalitions got together, like everyone, like the different community-based groups in PNG, for example, Pang in Fiji and everyone else, plus funders, plus like all these other players, like the stakeholders, so to speak, and got together and mapped out what is, for example, what is, we can agree maybe the most urgent campaign to take on, and just stop working on our individual campaign for a second, and just for like, say, like a quarter, like 1 quarter, to work together on a concerted global campaign targeting one entity. Do you imagine how much power we would have if we actually, like, part of what our problem is almost like strategically, sometimes we have to see the war and break it down into bite-sized battles and focus on them one by one and win them. Because winning matters too. Winning and building momentum for further pursuits. I think that's really important. So like if the region got together and supported one community-based organization or one initiative, I think that could be quite powerful. It's like a region showing up for one community and you go one by one. And then there are other times, obviously, when the situations will change and the tactics will have to change, and maybe we have to do many things at once. But I think we haven't tried enough of that first thing, you know? So that's just a lot of random ideas, but I think all of them sort of get to your question. And then the other question about Indigenous peoples, like we operate obviously from, which is, you know, there's a working global definition, although I wouldn't call it definition, I would say description of Indigenous peoples, because any like one definition that purports to stand in for all hundreds of millions of us, you know, is going to be inherently flawed. So like we have the, you know, there's a UN working description of Indigenous peoples, you know, there's clearly there's elements, and when you add them all together, the intermediate community looks at it and says, oh yeah, I recognize that, that's an Indigenous peoples. You know, this common language and history, usually they form non-dominant sectors of society, etc. There's different elements, but also the most important one I would say is self-identification, you know, groups that identify as Indigenous. So I think there's been some debate that's been a little needless, and that is who constitutes an Indigenous peoples in Pacific Island states, when sometimes in different states they can't be said to form non-dominant sectors of society. I think that's sort of like paying attention to the wrong thing. There's multiple elements, they meet all of them but one theoretically, but self-identification matters more than the others, in my opinion, as a practitioner. And so like clearly Indigenous peoples have arguments to make, and also the UN and different states in the Pacific Islands have like rectified the problem, often by framing it as Indigenous peoples and local communities. So it's like an alternative terminology that clearly everyone's sufficiently happy enough with. I can't remember anyway what the last question was, but I think that's related to the last question, right? Yeah, so I think that's I hope we answered it well enough for you folks. And I know it's literally 1 minute left. And so I guess we'll leave it to Maureen to wrap up.
Julie, I could see you wanted to say just something very quick.
Yeah, no, just on the application of FPIC to compensation. I think there is some guidance on this area. I'm not that familiar with it, but I think it would, there's various sources you could look at that would, and cases that would go into what types of settlements and what types of revenue sharing agreements and those sorts of things, or benefit sharing agreements have existed, especially in the case of resource extraction. In the case of environmental damage or pollution, I think it's just often the case that Indigenous peoples and usually local communities often just aren't compensated, but it's a developing area. So it's something that, we could look into more. And I think it is a good question, and there's some complexity there. So I just wanted to quickly mention that.
So we are really right on time. It's 1:30, that's an hour and a half in which we're committed to doing this really, really important session to kickstart 2021 during the Blue Line series. I really do want to thank both Julian and Julie really for their time, really to re-engage. I think Julian and I we were laughing before we came on live on, we've been in the trenches for a decade now on this issue. And the work of Blue Ocean Law, Julian, Julie, Clement to an extent, and how it has broadened it. And I think Julie's point that this is, even though we look at it from the lens of deep sea minerals, it touches on issues of colonization. It touches on self-determination, on climate and climate justice, on rights of peoples, and in particular Indigenous peoples. So widening this on just those minerals that sit on our ocean floor within our jurisdictions, and certainly beyond our jurisdictions. I think ending it really on the need to coalesce in ways that we haven't done for a while, learning from the experiences of nuclear testing in this part of the world, and how we can, through these kinds of coalescing, the need to shift the climate movements to pay attention, the need to shift human rights to pay attention to rights of nature. And I think we are in a good place. Pacific peoples are in a good place to lead these debates and discussions, partly because we live it. It is our lived experience, and that is what we bring to the global community. And it is one that I think is quite necessary. So I think the call to coalesce is a call to recognize that Indigenous peoples have disproportionately carried the burden consistently of responding to science, to laws, economic benefits, and rationalizing all of that. So I think it's timely. Thank you all for your time, those who signed in and who are watching live on Facebook. I think this takes us neatly into the next session on during the Deep Blue, the Blue Line. So on behalf of Dawn, Pacific Conference of Churches, Piango, Pang, and the team here, thank you all for your time and your commitment, ongoing commitment to issues that matter to the people and to oceans. Naka.